Former Chief Justice DY Chandrachud has ignited controversy with a remark in a Newslaundry interview asserting that the very erection of the Babri Masjid was a fundamental act of desecration. He pushed back against interpretations of the Ayodhya verdict by asking if the mosque's construction itself was a violation of history, how can one ignore that before focusing on later acts in the inner courtyard? This is especially jarring because in the 2019 Supreme Court's Ayodhya judgment, the one he was a member of, that decision explicitly held there was no conclusive evidence that a pre-existing Hindu structure was demolished to build the mosque. The judgment acknowledged that the Archaeological Survey of India's report hinted at underlying structures but also cautioned that it did not prove demolition or use of those remains in the mosque's construction. In his interview, Chandrachud claimed there was adequate evidence from the archaeological excavation and accused critics of the judgment of selective history. He urged that the court could not shut its eyes to what happened in history and even said that the commentators who are critical of it want to ignore the fundamental history of the mosque and then look at the more comparative and selective history in support of what they postulate. However, critics say his remarks do not reflect the balance of the original judgment and that title must be based on legal principles and evidentiary standards, not on unproven historical narratives alone. It raises a sharp question among many. Can a judge publicly assert positions that seem to contradict a judgment that they helped author? This is LiveLaw. Follow us for continuous and credible coverage of everything that is law.